Rachel Miller never intended to stand in a courtroom again, not like this, not as a defendant. At 42, she had long accepted that her dream of becoming an attorney had been quietly buried under layers of responsibility, lost opportunities, and life's unrelenting demands. She had once walked the halls of Westbridge University's law school with wide eyes and ambition in her chest, but 2 semesters before graduation, her father's sudden death and her mother's spiraling medical bills forced her to withdraw. She never returned. Instead, she became a mother, a full-time administrative assistant, and a woman who studied legal casebooks by the dim light of the kitchen table after her son was asleep. The books were outdated, borrowed or second-hand, but she read them with the hunger of someone who couldn't afford to forget who she used to be. The letter came on a Tuesday summit. Systems, a national home security corporation with a reputation for ruthless enforcement of customer contracts, claimed Rachel had violated the terms of her service agreement. According to them, she failed to provide sufficient notice before cancellation and now owed them $15,000 in penalties and late fees. The figure was staggering, more than her entire emergency savings, more than her car was worth. The letter was delivered in a crisp, impersonal envelope. Its tone was cold, the legalese deliberately intimidating. Her 16-year-old son, Luke, watched silently as she read it aloud, the color draining from her face. "Can we fight this?" he asked. "I mean, are they right?" Rachel didn't answer immediately. She stared at the fine print, then at the kitchen wall, where her old Westbridge student ID still hung in a cracked plastic frame. "They're wrong," she said, finally more to herself than to Luke. The next few days passed in quiet preparation. Rachel combed through her files, pulling out every email receipt and confirmation letter she had saved over the years. She printed call logs, highlighted timestamps, and organized her arguments with the methodical precision of a paralegal, except she wasn't one. She was just a woman in a blue sweater trying to hold her life together. That same sweater, warm but well kept, had once been part of her law school interview outfit. Now it would serve as her armor in court. Her legal training had stopped short of a degree, but her learning had never stopped. She knew enough about consumer contracts and dispute resolution to sense that Summit was bluffing, counting on her fear, not their facts, to win. When she informed the court she'd be representing herself, the clerk on the phone paused, then quietly offered her a list of pro bono legal aid groups. She thanked him, but declined. Rachel had spent the better part of 2 decades supporting clients preparing paperwork, drafting memos for junior associates at the insurance firm where she worked. She had written arguments she never delivered, spotted loopholes she wasn't allowed to correct, but now, with her son's college fund at risk, with her dignity under siege, she wouldn't remain silent. It wasn't just about the money. It was about reclaiming the part of her that had always believed in justice, even when life had told her it wasn't hers to pursue. On the morning of the hearing, Rachel stood outside the Jefferson County Courthouse, clutching her worn leather bag, the same one her parents gave her when she was first admitted to law school. The sun reflected off the courthouse's stone facade, casting long shadows across the steps. She looked up at the building not with fear, but with clarity. Inside, she knew the opposing lawyers would be dressed in tailored suits, confident and polished, backed by a corporation that had more attorneys than she had friends. But Rachel had truth preparation, and something more dangerous than credentials, she had nothing left to lose. The courtroom was everything she expected, formal, unforgiving, and filled with murmurs that stopped as soon as she entered. Across from her sat 2 attorneys from Summit Systems, whispering confidently to one another, their documents clipped neatly in leather binders. The bailiff's voice rang out, "All rise." Judge Wallace entered his black robe, flowing like a cape, his silver hair perfectly combed. He glanced at Rachel with the faintest trace of amusement, as if he had seen this story before. To him, she was just another unqualified defendant, another case to close before lunch. But Rachel stood tall, the blue sweater hugging her frame like a memory of who she used to be and a promise of who she still might become. Judge Wallace barely concealed his skepticism as he peered over his glasses at Rachel Miller, sitting alone at the defendant's table. He had seen self-represented litigants before, nervous, disorganized, overwhelmed. They usually stammered through their statements or folded at the first procedural objection. When he called her case Summit Systems versus Miller, his voice carried the tone of formality mixed with faint amusement, like a teacher calling on a student expected to fail. Rachel stood her palms flat on the table for a moment as she steadied herself. Then she lifted her head, met the judge's eyes, and calmly stated, "Rachel Miller, representing myself. Your Honor." Her voice, though soft, rang clear in the high-ceilinged room. It was the first hint that this case might not go the way anyone expected. Summit's attorney, Andrew Price, began his opening statement with the kind of confidence that comes from years of corporate litigation. He outlined the contract terms, emphasized the alleged breach, and concluded with a demand for full payment, plus interest and legal fees. It was a well-rehearsed performance, complete with a stack of documents and a tone of polite condescension. Price never once looked at Rachel as he spoke. Judge Wallace nodded as the attorney concluded, then turned toward Rachel with a practiced sigh. "Miss Miller, your response?" he asked, expecting hesitation, confusion, anything that would validate his assumption. Instead, Rachel calmly opened her leather bag, pulled out a clearly labeled accordion folder, and began distributing neatly printed copies of her evidence to the court and the opposing counsel. "Your Honor," Rachel began, "the plaintiff's claims are based on a misinterpretation of the termination clause within the agreement." She moved with quiet assurance, flipping to a highlighted section in the contract marked Section 4.3. It clearly states that notice of cancellation is deemed delivered upon sending, not upon receipt. Judge Wallace raised his eyebrows slightly. She wasn't just rebutting, she was navigating legal language like a seasoned attorney. Rachel went on to provide a series of certified mail receipts, time-stamped emails, and even an audio file transcript from her final phone call with Summit's customer service. Each item meticulously catalogued, each directly supporting her claim. As she laid them out, the courtroom's energy began to shift. Then came the moment no one expected. Rachel cited contra proferentum, the legal doctrine that ambiguities in a contract are interpreted against the drafter. She didn't fumble the Latin, nor did she over-explain. She simply stated it, backed it with precedent, and showed how Summit had inserted vague language in their post-signature amendment. Appendix B, without proper notification, Price fumbled with his own stack of documents, unprepared for the argument. The murmur of attorneys in the gallery grew audible. Judge Wallace leaned forward, slightly curiosity, now replacing indifference. "Miss Miller," he asked, "are you claiming this amendment was introduced after the original contract was signed?" "Yes, Your Honor," Rachel replied without hesitation. And under Rossman v. Fleetbank, unilateral changes of material terms require clear and conspicuous disclosure. Summit failed to meet that standard. The silence that followed was not empty. It was heavy. Judge Wallace no longer looked at Rachel like an amateur. Instead, he studied her carefully, his fingers steepled beneath his chin. The gallery of legal professionals had taken notice too. The woman in the blue sweater wasn't merely holding her ground, she was teaching a masterclass in consumer contract law. Every citation, every clause, every fact she presented built her case with the precision of someone who not only understood the law, but respected it. Her lack of a formal law degree no longer mattered. What mattered was that she was right, and more importantly, she could prove it. By the time Rachel sat down, the courtroom felt transformed. Summit's legal team shuffled their notes nervously, whispering among themselves. Judge Wallace did not dismiss her with a gavel or a sigh. Instead, he nodded once, just once. But it was enough. It said, "I underestimated you." Rachel didn't smile, didn't gloat. She simply looked down at her notes, made one more underlined annotation in her binder, and waited. The courtroom had expected a quiet collapse. What they witnessed instead was a legal storm delivered in the calm, steady voice of a woman who never stopped learning, and who now finally had the floor. Just when it seemed Rachel Miller had turned the tide, Summit Systems made a sharp and calculated pivot. Their lead attorney, Andrew Price, adjusted his tie, stood, and coolly introduced a new argument. Your Honor, pursuant to Section 11 of the Service Agreement, any dispute arising from the contract must be resolved through binding arbitration. He declared, his voice taking on an edge of finality. We move to dismiss this case in favor of arbitration, as clearly specified by the parties' agreement. Judge Wallace leaned back in his chair, intrigued. It was a well-known strategy, one used by corporations to funnel consumer disputes away from public courts and into closed arbitration proceedings where they held a tactical advantage. Rachel's heart pounded, but she kept her expression composed. She had anticipated this. She stood slowly holding up a printed copy of an email dated February 17th. Your Honor, I'd like to direct the court's attention to Exhibit C in my filings, she said. This email sent by Summit's legal department explicitly states that my cancellation dispute had been escalated for resolution in the appropriate venue. Their decision to engage with me outside of arbitration constitutes a waiver of that clause per Howard Vi, Ferrell Gas Partners. She handed the judge a copy, her posture firm, her delivery calm. A ripple of quiet murmurs spread through the gallery again. Price looked momentarily rattled. Judge Wallace adjusted his glasses and reviewed the document with visible interest. It was clear Rachel was not only citing precedent, she was applying it with precision, and she wasn't done. Additionally, she continued, the arbitration clause requires that all hearings take place exclusively in Phoenix, Arizona, despite the fact that Summit operates nationally and I am a resident of Virginia. That geographical restriction imposes a disproportionate burden on the consumer and makes the clause unenforceable under the doctrine of unconscionability. Judge Wallace raised an eyebrow. Miss Miller, he said slowly, are you referring to AT&T Mobility v. Conception? Rachel nodded. Yes, Your Honor, in part. While Conception upheld the validity of arbitration clauses in general, it did not eliminate unconscionability as a defense. Later rulings, including Chavaria v. Ralph's Grocery and Newton v. American Debt Services, reaffirmed that such clauses can still be invalidated when they are both procedurally and substantively unfair. That was the moment Judge Wallace decided to push. He typed briefly at his bench computer, then looked up with the glimmer of a challenge in his eye. Miss Miller, are you familiar with Selden v. Airbnb, D.C. District Court, 2016? The courtroom held its breath. It was an obscure case, cited rarely outside academic circles, concerning arbitration clauses hidden deep within online terms of service. Rachel paused. She didn't bluff. Not directly, Your Honor, she replied with steady candor. But if I may ask, was the case about enforceability when terms were not clearly disclosed to the consumer? Wallace's face remained unreadable. Precisely, he answered. And your position would be... Rachel took a breath, letting her mind work through what she had read in related decisions. Then I would argue that Selden supports my position. Summit buried changes to essential contract terms within a dense service update email without any clear flag or requirement for acknowledgement that undermines informed consent. Even the most seasoned attorneys in the room exchanged glances. Rachel wasn't just holding her ground, she was threading the needle between honesty and legal insight, balancing humility with mastery. Summit's senior counsel, Richard Harmon, who had remained silent until now, stood up. He was a veteran litigator with decades of experience and a reputation for dismantling opposition with quiet efficiency. Your Honor, he said, Miss Miller is selectively interpreting precedent. While unconscionability is a valid doctrine, it must meet strict thresholds. Conception reinforced that federal policy favors arbitration, but Judge Wallace was no longer staring at Harmon. He was watching Rachel Miss Miller. He prompted, your response. Rachel's reply was clear, grounded, and unshaken. Your Honor, I agree that Conception emphasized the FAA's preference for arbitration, but it did not erase consumer protections. In Chavaria, the Ninth Circuit ruled that a clause mandating arbitration at the employer's headquarters, accompanied by a fee schedule too expensive for a typical worker, was unenforceable. The same principle applies here, requiring me to travel cross-country at my own expense for a dispute. Summit initiated strips me of practical access to justice that is both procedurally and substantively unconscionable. Wallace said nothing at first, but his gaze lingered on Rachel for a long moment, no longer with doubt, but with something closer to admiration. She had met the ultimate test, not with bravado, but with the depth of someone who had walked through fire and emerged stronger. The courtroom had grown so still that even the ticking of the old wall clock seemed loud. Judge Wallace sat with his fingers steepled, studying Rachel Miller as if seeing her for the first time, not as a defendant, not as a self-represented amateur, but as something else entirely. He closed the file in front of him slowly, then looked up Miss Miller. He said, his voice less formal now, almost reflective. Given the complexities of this case, and the questions raised about the arbitration clause's validity, I believe we would benefit from mediation. He paused, glancing towards Summit's counsel. I know a retired federal judge who handles such matters on referral pro bono. The room buzzed softly at the unexpected shift in tone. Rachel turned to face the judge, fully eyebrows raised, not in resistance, but in surprise. I would welcome that, Your Honor, she said. Before dismissing the court, Judge Wallace cleared his throat and added, Miss Miller, if you could remain after the session for a brief conversation in chambers, I'd appreciate it. The request landed gently but firmly, and Rachel felt her stomach tighten, not from fear but curiosity. She waited outside the judge's office for 20 long minutes, staring at the certificates lining the hallway wall. When the door opened, Wallace gestured her in, motioning toward a chair across from his desk. The room smelled faintly of old books and coffee. I'll be honest with you, he said after a moment of silence. You've given me the most thought-provoking morning I've had in months. He set his glasses down and leaned forward. You should be in a courtroom. Rachel, on the other side of the bar, practicing law, not defending yourself. Rachel sat very still, unsure how to respond. Her voice finally came quiet, but clear. I was on that path. Years ago, life pulled me off of it. Wallace nodded slowly. Virginia State, he asked. She nodded. That's where I went, he said with a faint smile. They now offer an evening program. Flexible, more accessible, and there's a scholarship I helped create 5 years ago. It's called the Wallace Justice Scholarship, specifically for people who never got their chance the first time around. He pulled a business card from a drawer and scribbled a name and number on the back. This is the Dean of Admissions. Call her. Let her know I recommended you personally. Rachel stared at the card, emotions rising faster than she could suppress them. Thank you, she whispered. Just consider it, he said. The law needs more people like you. 2 days later, the mediation was held in a quiet conference room at the courthouse. Retired Judge Michael Coleman presided over the session with a calm, seasoned presence. Rachel sat across from Summit Systems' legal team, now joined by a new face, an older man in a charcoal suit, Summit's senior counsel. They began predictably reiterating their contractual position. But Judge Coleman cut through the posturing. I've reviewed all the documentation Miss Miller has provided. He said her timeline is sound. Her notices were made in good faith, and her interpretation of the contract's language holds water. Summit's lawyers huddled for a moment. Then their lead counsel spoke. We're prepared to waive all penalties. Miss Miller would only be responsible for base service charges up to the date we processed her cancellation. Rachel didn't blink. I accept, provided Summit also confirms in writing that my account is closed, no balance remains, and no negative report will be submitted to credit agencies. There was a pause, then a nod. We'll have the agreement drafted by morning. Summit replied. The mediator smiled faintly. That seems more than fair. Rachel had done it. Not only had she stood her ground against one of the country's largest consumer corporations, she had walked away having rewritten the terms of the conversation. As everyone gathered their belongings, Lisa Brooks, one of Summit's younger attorneys, approached her. That was exceptional. She said, Are you actually a lawyer? Rachel smiled and shook her head. Not yet. Lisa handed her a card. When you are, give me a call. Our firm needs people who can think like that. As Rachel walked down the courthouse steps into the afternoon light, she felt something she hadn't felt in years. Hope, real and solid. The legal weight that had threatened her home and her son's college fund was gone. But more than that, she held in her hand the card that might very well change everything. Judge Wallace's referral was more than a courtesy. It was a door cracked open, one she thought had closed forever. That evening, as she taped the card to the refrigerator next to her son's honor roll certificate, Rachel didn't just feel like someone who had won. She felt like someone who had returned to herself her purpose, and perhaps at last, her calling. 1 year after the courtroom battle that changed everything, Rachel Miller sat in the front row of her civil procedure class at Westbridge University's evening law program. Her navy blue sweater, the same one she'd worn when standing alone against Summit Systems, was draped neatly over the back of her chair. In front of her, a casebook lay open, its margins marked with handwritten notes and citations. She was no longer the woman desperately defending herself in court. She was a law student again this time, with purpose, maturity, and the kind of life experience that couldn't be taught in textbooks. Thanks to the Wallace Justice Scholarship, she'd been able to return to the path she had once walked away from, and this time she wasn't looking back. At 43, Rachel was older than most of her classmates. Some were recent undergraduates, still unsure why they had come to law school at all. Others were driven but untested. Rachel, however, carried with her the quiet conviction of someone who had already stood in the ring and won. Her professors quickly noticed. She didn't just know the law, she understood its intent, its implications, and its impact on ordinary people. She asked the kinds of questions that made others pause, that made the room lean in and listen. Within months, she had become a go-to peer for complex discussions, group assignments, and practice arguments. What she lacked in traditional credentials, she more than made up for in real-world wisdom. Word of her courtroom story had quietly spread across campus. Some thought it was a rumor. How could a legal assistant with no formal license take down a corporate legal team? But the truth was more compelling than fiction. One afternoon after class, she found an envelope in her mailbox. Inside was a handwritten note from Lisa Brooks, one of the Summit Systems attorneys she had faced during mediation. Lisa congratulated her on re-entering law school and offered something more, a future. When you graduate, the note read, "Call me. Our firm is always looking for attorneys who don't just argue well, but who understand justice." Rachel read the words twice before carefully sliding the note into her law binder. It didn't feel like a favor. It felt like a door opening. And then came the announcement that the next moot court final would be presided over by none other than Judge Wallace himself. Rachel's name was on the shortlist of finalists. Her classmates buzzed with nerves, but Rachel felt something different. She felt full circle. The same judge who had once looked at her with quiet doubt now seemed invested in her journey. When her professor pulled her aside and said, "He rarely volunteers for these sessions. You must have left an impression." Rachel simply smiled. She didn't need to explain. She knew what that courtroom moment had meant, not just for her case, but for her identity. In preparation for the competition, Rachel stayed late in the library most nights, researching her arguments, perfecting her tone, and rehearsing until every word felt lived in. She wasn't performing for accolades. She was speaking for every person who had ever been underestimated, every woman who had walked into a courtroom alone, every adult who dared to return to school after life had knocked them off course. The stakes weren't just academic, they were personal. And yet the closer she got to the day of the competition, the more at peace she felt. She had already won something more valuable than any mock trial trophy, her self-respect. On the day of the moot court, Rachel stepped into the same courthouse where her battle against Summit had unfolded. This time, however, she wasn't seated at the defense table. She stood at the lectern as a future lawyer, her presence commanding her voice, unwavering. Judge Wallace sat at the bench, expression unreadable, but Rachel could see the flicker of something deeper in his eyes, recognition, perhaps even pride. As she delivered her arguments with clarity and conviction, she felt no need to prove herself. She had already done that. Now she was simply stepping into the role that had always belonged to her. And when the final gavel came down, the courtroom didn't just see a law student, they saw a future attorney who had fought her way there, one case, one class, one challenge at a time. If this story moved, you don't forget to subscribe to Deep Inside HQ, where every story uncovers the strength, dignity, and quiet brilliance that often go unseen. From underdogs rising to silent heroes finding their voice, we bring you real, powerful narratives that remind us all courage is louder than doubt. Share your thoughts in the comments. Tell us how Rachel's journey inspired you, and hit the bell icon so you never miss a moment of transformation. At Deep Inside HQ, the truth isn't just told, it's felt.